All right, guys, welcome back to the channel, the Butterfly Monkey Effect. Hopefully you guys are all caught up with the videos I've been making on this passport and the right to travel, which of course, if you have been watching, this is a government document printed in 1966. And it's literally an analysis of the history of the passport and how it affects your right to travel. So this is part 5. This is going to be mostly court cases. So hopefully you guys will enjoy this and learn from it. So to start, the court case is Bodine versus Dulles. And to make sure this is where I left off. Yeah, okay, right there. Washington Circuit Judge, the Secretary of State refused to issue a passport to Leonard B. Bodine on the ground that issuance was precluded under Section 51.135 of the passport regulations. So today's day, if that's still in existence, is going to be 22 CFR 51 point and wherever it's at. Because Part 51 is flat out passports. On the basis of all the evidence, including that contained a confidential reports of investigation, Bodine then sued in the district court for a judgment that he, as an American citizen, is entitled to a passport and that a passport regulations are invalid. He also sought an order directing the Secretary of State to issue a passport to him forthwith. The district court held that the applicant had a right to be confronted with the evidence against him in order to permit him to rebut or explain it, and to enable the courts to review the decision. It sent the case back to the passport office, ordering that a hearing be held within 20 days thereafter, and that the decision of the passport office be substantiated by evidence contained in the record made by such hearing. Both the Secretary of State and Bodine have appealed. So one thing I don't know if they're going to talk about it, but how he states that he's entitled to it. Okay, that's what they say today. On the basis of just being a citizen of the United States, right? They owe, that's an entitlement to you. That's like a given. And you can only because it's a direct effect to your right to travel. So any denial to it you must be given due process of law. There's no escaping that. This book showed that clearly, on the history on it, on how it has changed. Section 51.135 of the passport regulations provides for denial of passports to 3 classes of persons who are enumerated and described in subsections A, B, and C thereof. Although the Secretary relied solely on this section in his letter, notifying Bodine of his decision not to grant him a passport, he did not there specify which subsection barred issuance of a passport to Bodine, nor did he set out any findings indicating that Bodine fell into any of the 3 classes of persons described in the regulation. The Secretary later filed an affidavit in the district court in which he stated, "The basis for my decision to deny the plaintiff further passport facilities rest on a pattern of associations and activities on the part of the plaintiff over an extended period of time, leading to the conclusion that the plaintiff has been and continues to be a supporter of the communist movement." But the whole thing is they didn't tell him that. Like, you got a right to confront that. Like, they got to tell you why. For present purposes, we accept the Secretary's affidavit as a statement that he has found that Bodine is a supporter of the communist movement, even though such finding was not communicated in his letter notifying Bodine that issuance of a passport was precluded by Section 51.135 of the passport regulations. Subsection B of the regulations cited is the only part thereof which refers in terms to those who support the communist movement. But that subsection is not mere phrase to deny passports to every supporter of the movement without more. So that's the key right here. It's always going to be that, right? But that subsection, meaning the statute, is not phrase to deny to every supporter of the movement without more, right? Meaning your way of thinking is not the only thing that they could use to deny you. It states that passports shall be denied to persons who engage in activities which support the communist movement under such circumstances as to warrant the conclusion, not otherwise rebutted by the evidence, that they have engaged in such activities as a result of direct domination or control exercised over them by the communist movement. In this letter to Bodin, and in his letter to Bodin, and even in his affidavit to the secretary, has set out no finding or conclusion that Bodin alleged pro-communist activities were the result of direction, domination, or control exercised over him by the communist movement. So what's the difference? You're being told what to do. You are being organized to do something. Now, if you're just an individual and you're not participating in none of that, but you have this same ideology, okay, well, there's no one directing you now. Now it's just a belief, like an ideology that you have. And they can't deny you on that just because of the way you think. We'll learn there's court cases coming up that are in the 1960s that explain this thoroughly. Court case that I already read, but it's going to be nice seeing it in here with the analysis that they're giving. He has thus failed to make the finding contemplated by subsection B, nor has he set out findings which would render subsections A or C applicable. Or I just leave off at. On the record before us here, which of course contains none of the confidential information on which the secretary says he in part relied, we cannot assume that findings sufficient to bring Bodin within any subdivision of the regulation were secretly made. Bodin within any subdivision of the regulation were secretly made, or that they will be made. In an affidavit executed June 3rd, 1954, Bodin swore that he was not then a member of the Communist Party, nor otherwise a person described in Regulations 51.135, subsection A, and that I am not going abroad to engage in activities which will advance the communist movement in violation of subsection C, but for the purpose indicated in my correspondence with the passport office. At the review board hearing, he testified under oath that he had not been a member of the Communist Party at any time since June 3rd, 1954, and that the facts stated in the affidavit continued to be true. Now, why is this important? Because what did the judge say up there? Unless it's not otherwise rebutted by evidence. So we know that the Secretary of State didn't give nothing to prove his point, right? That's a fact. That's what this judge is saying, all right? So what does the affidavit do? Man, that's evidence that needs to be rebutted. And if no one rebuts, that's true. So, it's the way it is, right? His testimony bearing on the applicability of subsection B cannot be described as particularly frank or helpful, but he did to some extent outline and seek to explain as non-subversive his activities in connection with several organizations and publications alleged to the communists to be communist. And he did state that he was never ordered or directed, as distinguished from retained by the Communist Party, to defend any individual or associations in a legal capacity. And look at how he started, right? He's saying that basically most of the crap he was talking about don't mean shit. But because he actually did state that he's not doing these specific activities that he could be accused of in the statutes, man, that's like good enough right here. Well, at least for me right here, that's good enough. Before the Secretary of State may deny a passport under authority or regulation specifying 3 classes of persons to whom passports should be denied, factual findings to bring applicant within one of those classes are required. An applicant who has not advised under which provision his application was denied was entitled to have findings responsive to the regulation. And this is important too. In my case, right, it's the denial because of the non-furnishing of a social security number. The question is, can they bring me under that regulation? Right? To bring the applicant within the class that's required, right? And you can't. I need to have a foreign residency for income tax purposes. So it's either going to be this. If I do fall under that category, then they just admitted that the state that I'm in is a foreign residency in this context. But because it's a passport, I do not believe it's a foreign residency, right? Because it's not dealing with commercial law. But I could be wrong, right? But that's the whole point. I'm trying to find out. An administrative order cannot be upheld unless the grounds upon which the agency acted in exercising its powers were those upon which its action can be sustained. Administrative action cannot be upheld merely because findings might have been made and considerations disclosed which would justify the order in absence of a reasonable finding. Number 4. The matter must therefore be returned to the Secretary for reconsideration. He may conclude that a passport should be issued or that a further hearing is needed. But if he decides, with or without an additional hearing, that issuance of a passport would not be warranted under the regulations, he should advise Bodin in writing of the findings made, relating them to the sections relied on. We do not reach in the present posture of the case the contention made by Bodin that the Secretary cannot rely on confidential information in reaching this decision. So what did they just say? Confidential information could work. Like it doesn't. If he's claiming it, right, and hoping that it's true, he could be denied for that shit. But you would think that there has to be something of a record to even show that there's a confidential informant stating these things. Might not ever know who he is, but nonetheless, they have evidence of these things being stated. But since that question may arise at the subsequent stage, we think the Secretary should, if he refuses a passport to Bodin after the further consideration we have ordered, state whether his findings are based on the evidence openly procured or in whole or in material part on secret information not disclosed to the applicant. If the latter, the Secretary should explain with such particularity as in his judgment the circumstances permit the nature of the reasons why such information may not be disclosed. And they give you a court citation here. This will facilitate the task of the courts in dealing with the question of the propriety of the Secretary's use of confidential information, a question which, we repeat, we do not now reach. When the Secretary has made his decision upon reconsideration, Bodin may then proceed as he may be advised. The district court should retain jurisdiction for that purpose. If the passport is still refused by the Secretary and further judicial review is sought by Bodin, the district court may consider whether the findings made are justified by the evidence of record, or if they are not so justified, whether the Secretary has given reasons valid in law for keeping confidential any information not disclosed to the applicant, upon which he states he has relied. The district court may also consider if the question becomes material whether the passport regulations are valid in their application to Bodin, as then determined by the Secretary, a question which we do not now reach and express no view upon. For the reasons given, the litigation must be remanded to the district court for further proceedings not inconsistent with this opinion. So we don't know the result of that. But this is a case that I might use because this is a case that specifically is stating that you need to qualify the applicant under that statute for you to be able to deny him. It might be confidential, whatever, but you still need to qualify him. That's what I'm looking for. They need to qualify me for that statute, for that regulation to apply to me. Kraus versus Dulles, July 5th, 1956. Washington Circuit Judge, plaintiff appellate seeks a passport to travel abroad. Failing to obtain favorable action by the State Department on his application, he brought this suit in the district court for declaratory and mandatory relief. The district court granted appellee's motion to dismiss for failure to state a claim on which relief may be granted. This appeal followed. Appellate says that the purpose of his proposed trip is to gain backing in his effort to submit what he demonstrates the Kraus case to the UN Commission on Human Rights. The Kraus case appears to be appellant's protest against his dismissal in 1933 for reasons which do not appear in this record from the faculty of the City College of New York. To this effort, appellant has devoted most of his energies since 1933, and his gainful employment has been intermittent since that time. He is without funds or property and is dependent upon contributions from sympathizers and from charitable organizations. He has on at least one occasion also been supported by a public welfare agency. To me, he's complaining because he lost his job that, I don't know how much that's going to work, like the problems that arose, right, when it's really going to be the issue of why, the reason why he got fired. Well, the after effect really don't mean shit. Well, I would think so. There is some doubt as to the circumstances of a previous controversy between appellate and the State Department. The department asserts only that appellate required the financial assistance of the department to the extent of $95 in securing return transportation to the United States from Costa Rica in 1951, and that he has not repaid this money. Appellate asserts that he was about to depart Costa Rica for Panama when an American consular official in Costa Rica took away his passport on the ground his presence was undesirable and would give it back only to permit direct return to the United States. Appellate states that he had prospects of receiving remuneration for lectures in Panama. So this is now about business now. Fuck the other stuff about what he's saying about his job and all that stuff. He owes money to them because he was asking for money because he's broke and he needs to travel, right? But this right here is business. Appellate states that he has prospects of receiving remuneration for lectures in Panama and that he became destitute and had to accept the State Department's offer of funds to return him to the United States only because the department's action in taking away his passport and thus forcing him to return. Subsequent to his return, appellate's passport was renewed for 6 months, but only after he had required to submit and did submit evidence of his financial ability to travel. The evidence consisting of a bank deposit of $1,000 derived from contributions. In 1954, appellant made a passport application, which is the basis for the present suit. The State Department advised him that it took no position on the Kraus case and that it had no objection to his traveling abroad for the purpose of gaining support for his case. To me, that's probably bullshit. that they denied him because of his lectures. However, the department declined to issue Apella the passport unless he could show that he had the necessary funds with which to travel abroad and return home. That has nothing to do with receiving a passport. Now, if you have no funds and you're trying to travel somewhere, do you think that matters to the other country? I would say so, because it matters here. Otherwise, they look at persons like that as public charge. Well, basically wards of the state, right? But a public charge. The department also expressed displeasure at the fact that appellant's past travels has caused Foreign Service offices of the United States to receive numerous troublesome and vexatious inquiries, so irritable inquiries about appellant's activities. Appellant declined to make the submissions requested and instead brought this action to the district court. It is clear that the denial of a passport by the Secretary of State is subject to a measure of judicial review, including the question whether the action of the Secretary was arbitrary or capricious or contrary to the law. See, that's great right there. I will be using, and it's emboldened too, so that's good. Highlight that right there. We think that in the instant case, there is sufficient likelihood that the reason given represents arbitrary and capricious action to render the grant of appellee's motion to dismiss. Before answer and before hearing unjustified. In the instant case, some officials of the Department of State indicated in their correspondence with the appellate that the department has a long-standing policy that it is not favorably disposed to issue passport facilities to persons who appear likely to require financial assistance in accomplishing their proposed travels abroad. And the State Department official has testified before a Senate subcommittee that some 120 passport applicants were screened on a financial basis during the 10 months period from January 1st until October 30th, 1955, with a result of 25 rejections for financial reasons. On the other hand, appellant's attorney in the district court submitted an affidavit that he had been advised by the State Department that no requirement relative to money or property was ever made of a passport applicant, and that in fact no such requirement had been made in applicant's case. So basically saying no statute and no demand by whatever agent you're talking to. And an examination of the extensive regulations of the President and the Secretary of State relating to the issuance of passports shows no evidence of the existence of any such policy. It is clear from the questions required to be answered on the passport applications that there is not the slightest effort to screen the great majority of passport applicants on a financial basis. It thus is quite possible from the record, as it now stands, that the State Department has applied to the appellant a test it does not apply generally to passport applicants, and that this has been done without the establishment of any reasonable classification which could justify such discrimination. If such action has occurred, it is arbitrary and capricious and must be set aside on judicial review. Now this right here is completely color of law. Why do I say that? Because they are trying to enforce something that there is no law for at all. Like at all. That's different than like what the other cases above have been stating. We are reinforced in our view that dismissal was not justified because the establishment of a means test for passport applicants, particularly at a time when a passport is required for most foreign travel, would obviously raise serious constitutional questions. These ought not to be passed on in the present unsatisfactory state of the record as to what the State Department's policy is and how it is applied. Compare Naim versus Naim, Rescue Army versus Municipal Court, particularly since there is the non-constitutional ground suggested above, which may possibly be decisive. Accordingly, the order of the district court must be vacated and the case remanded for further proceedings not inconsistent with this opinion. For me, those people who believe that court cases don't mean nothing are fools. Fools. They don't even know the definition of opinion in law. The premise for the Secretary's ruling was not the financial worth of Krause. The premise was the sum total of the facts concerning Krause's manner of supporting himself while abroad. Depending upon charitable handouts, his total lack of resources, direct or indirect, whereby he might have some assurance of being able to return home, and the fact that he had lived on relief or on charity for some years. The conclusion of the Secretary was that upon those facts, it was not in the best interest of this country to have Krause traveling abroad. The financial showing provision was an escape clause, a means whereby Krause might extricate himself from the predicament in which the whole of his history and circumstance placed him in. I see nothing arbitrary or capricious in the Secretary's determination that to let a man in the conditions depicted in Krause's affidavit travel abroad under the aegis of the United States passport is not consistent with the best interests of this country. Give me 1 second, guys. The point can be made clear by reversing arguendo the situation. Suppose France, Italy, or some other country knowingly issued passports to panhandlers for the purpose of letting them travel around the country, begging their way. Would such a practice be in the best interest of the country issuing the passport? Obviously, it's not, I think. So, that's crazy. I am of the opinion of the Secretary of State has a measure of discretion in the issuance of passports. Foreign relations are involved, and such relations lie largely within the good judgment of the executive branch. And they quote, in Schachman versus Dulles, for reasons thus suggested, the issuance of passports throughout our history has been left to the judgment of the Secretary of State under presidential regulations and is subject only to constitutional safeguards. And even these must be defined with cautious regard for the responsibility of the executive in the conduct of foreign affairs. The ground upon which the Secretary acted in the case at bar seems to me to be both rational and reasonable. I would affirm the order of the District Court. Now that's fucked up right there. But it is what it is. Paupers will not travel if you can't afford it. But they don't ask these questions even now. So how they determine that is probably based on information you gave them. But with that, I'm going to end this little section right here and start a new video after these court cases and just start again. All right. So follow up on the next one and I'll catch you in a few.